we are targeting specifically lockouts, but there's a long list of different laws that are violated. Contrary to law has a well-documented meaning. If I go down to, I think it's paragraph 78, I have 3 different federal court cases talking about jurisdiction. That section 29C11 analysis contrary to law analysis includes actions both contrary to law and as well the claimant's union contract. There's federal court cases, there's 3 of them, saying the term illegal has a broader meaning than merely contrary to criminal law. They include contraventions of employment standards, legislation, collective agreements, and licensing board certifications. And these cases go all the way back to the 80s. So there's a well-documented history. And if I pull this list up here again, you can see here's just some of the things. Collective agreements, at least federally, have force of law under Section 168 of the Canada Labor Code. I'm going to focus more on lockouts. Lockouts are what we're targeting because everyone who had an employment contract that was unionized experienced a lockout. That's the only violation of law we have to prove. Of course, there's all kinds of Bill of Rights concerns. There's falsifying employment records. There's state action issues, right? Where by proxy, they're coercing private corporations to do something they can't do themselves. There's all kinds of case law. These 3, I'll come back to that. Cabiakman is a well-affirmed Supreme Court decision saying if someone is on a unilaterally imposed administrative leave of absence, got to be paid if they're ready, willing, and able to work. There's
Cabiakman.
Consent violations.
Hop versus Lep.
We have that in there. And there's all kinds of verification from different senators and House members and legislation writers showing they intended for this to be the case.
And can we just pause for a quick second to talk about, I think there's some value in discussing the debates that took place regarding the changes in the Unemployment Insurance Act. And I think you said there was it 400 debates? Is that correct?
4,500 pages.
4,500 pages.
And that was just for Bill C-21. It's almost 6,000 if you take the subsequent bills as well.
And just to help everybody here, that bill was adding in these, I guess, clauses for the just cause to find.
It was a transition from a socialized program to, obviously we can't give everyone EI. We have 2 problems. We have a financial deficit because we have mass unemployment at a time when everyone's on unemployment. So we have a funding issue.
And what year was that, just to give again some context to that?
88 to 90 was the study. 1990, early in the year, was when it was relevant. So the solution to the funding problem is we're just going to stop putting government money into it. That causes huge cost overruns. Now you have to deal with that. And their solution was, well, we're just going to deny you EI if you don't have just cause. Just cause was well established in jurisprudence, but that term had never been used in statute. So just cause appeared more than 450 times in their debates. At the end of the day, it was decided if you're going to completely deny someone EI if they don't have just cause, then you better define in statute what just cause is and stick with it. And up until 2019, that was well known, it was understood. It wasn't until there's expected situations that would change the demands on the program where it becomes inconvenient to. We can't examine if employers are breaking the law, if the employers are breaking the law because they're being coerced to do it by the government themselves.
Exactly. And I just wanted to stop on that for a moment because the parliamentary system is so watered down and weak that you will not find such intense debates on the new legislation that's coming forward. It's 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 really interesting to understand how much discussion took place on these old bills compared to what's happening today. And I just wanted to address that for a moment.
Thank you. And that was actually called out too. There were unions who were calling out that this unilateral revocation of EI for huge amounts of people was unprecedented. That prior there would be like huge cross Canada studies where all the provinces have a chance to weigh in, the citizens unions have a chance to weigh in. To arbitrarily drop this into a spending bill, it's
Mm-hmm.
to be clear, it's a UI reform. You're
Mm-hmm.
reforming how the program works,
And
but
it's
you're
spent
making that reform change in a spending bill, which is a supply bill is a confidence vote in Parliament.
and
So you're
so
forcing people to either vote for the change or they're voting for an election.
right. And when you say spending bill, are you talking about like a budget implementation or a budget bill?
Correct.
Yeah.
Yeah, the Budget Implementation Act. They buried a
That
policy change in a Budget Implementation Act.
those bills, these budget implementation act bills are insane. And they have where they are now is they're reshaping policy in many pieces of legislation, and people have no idea. And I think the people in the House have no idea as well. So it's interesting to see that this is how far back this is going. I mean, this is what, 35 years ago, 36 years ago.
Yeah.
Yeah.
Yeah, I think it's totally a Nancy Pelosi. We've got to vote to see what's in it. Like they're 1,000-page omnibus bills. Do we
Mm-hmm.
actually think that every member of parliament has read a 1,000-page bill and actually considered the implications of every single line?
Hell no.
When each line can have massive implications.
And you see how fast, if you go look at the history, like for example, the 2019 Budget Implementation Act that changed the Quarantine Act, so they no longer required parliamentary oversight to create the regulations, right? The uncanny
Mhm.
timing on that. It went through the House in like 2 days, and it's like I don't know how many, I forget how many pages, hundreds of pages, and it's just not possible to have these meaningful and proper discussions in the House through these bills. And this is important because the people who are supposed to be representing us, which we know they are not, they can't do their jobs. And we all know, even the best intended, there's pressure behind them to just push it through. And they're making enough money that they'll just do it.
Yeah, and once Parliament gives up that authority to regulatory agencies,
Yep.
I mean, at least if it's done by statute, there has to be a majority of the House willing to sign off on something. When it's farmed out as a regulatory decision, then does he even have to be a minister, or can just someone who's under the minister's authority
Mm-hmm. Mm-hmm.
issue a regulation change that nobody pays
Yep.
attention to in
Yep.
so just to tie up this jurisdiction, and then I'll let you ask your jurisdiction questions. This is the Canada Labor Code because we are federally regulated, but I've looked and every province has a similar provincial statute, the Ontario Labor Code here.
Mm-hmm.
Canada Labor Code Section 3 under interpretation. Again, this is binding for the whole statute unless it's refined somewhere within. Lockouts include the closing of a place of business, a suspension of work by an employer, or a refusal by an employer to continue to employ a number of employees done to compel those employees to agree to terms and conditions of employment. So if you
Mm-hmm.
want to force something new on them and it's not in the contract, if you just say, yeah, we're not going to pay you until you do it, that's called a lockout. That is the only definition of lockout. Section 88.1, strikes and lockouts are prohibited during the terms of a collective agreement. And every CBA that I've seen also has a prohibition. So it's a statutory violation of the labor code in whatever jurisdiction you're in, and it's also going to be violating the collective agreement itself. it is agreed for the duration of the present agreement, there should be no strike, nor lockout, nor slowdown, nor partial or total stoppage of work, nor study session. The parties agree not to counsel or encourage strikes and lockouts. So if you have a policy that coerces HR to lock people out and conditions their job on whether or not they file the proper paperwork, what are we doing? So I think this is an important jurisdiction, because if you have a contract, this hits everybody, whatever jurisdiction you're in. That's both a statutory violation and a contractual violation. And the precedent is clear for 30 years. When you have statutory and contractual violations, that is part of contrary to law analysis. So what jurisdiction questions were you going to?
Well, my jurisdiction questions were more related to the health, the consent, informed consent, and also with regards to the Regulated Health Professions Act. So because there is no federal healthcare in Canada, the healthcare services are managed on the provincial level, then all of the laws regarding healthcare are provincial. So I'm just going to speak to Ontario. We have the Regulated Healthcare Professions Act, which has controlled acts, what they can and cannot do. We have the Healthcare Consent Act, which states that any type of procedure must be consensual. And then you also have the Personal Health Information Protection Act that states that you cannot be coerced into giving up your personal and private medical information. And now this was happening. I mean, come on, you had 15-year-olds at McDonald's going, "Can I see your vaccine passport?" Like there was just a complete disregard for this law, these laws, I should say. And I think, disregarding the consent aspect, because again, let's just operate on the guise of their saying, well, it was your choice. Even the fact that you had employers trying to enforce or to coerce their employees into a medical procedure, which is a controlled act under the Regulated Health Professions Act, as you know. So I can see that you have this up on the screen. And do you know if any of the other cases that have been before the tribunal or have been before the Federal Court of Appeal, if anybody has discussed this major jurisdiction issue with regards to just the health services in general?
We can only go by the decisions that the tribunal released. I haven't. So this here comes from our factum. This is our 12 points at issue, which is part of the factum. Questions 3 to 12 are the core of our case. The first two, which is jurisdiction, we are putting before the court to answer, but we are not making any arguments, because based on the EI Act and the DESTA Act, there is no possible way that a tribunal member could have the jurisdiction to be making rules or rulings on things like the Health Act, the Quarantine Act, and other pieces of legislation. So while they're very important jurisdictional questions, only a court can answer those questions. So it's possible, in fact, it's likely that probably many people tried to raise these arguments at the tribunal, but because they're only under the DESTA Act to interpret the EI Act, it is legitimately outside their jurisdiction to answer questions like that. That would take a challenge, right? A statutory challenge.
Right.
On the legislation itself. And of course, the courts were shut down during that time.
How convenient.
So, yeah.
Okay.
But yes, it is. We are specifically asking those two questions. Who has jurisdiction for health related based on Section 91, placing quarantine at federal, not provincial, and also the Department of Health Act saying that you can't exercise jurisdiction over any health authority of a province. We are absolutely asking the court to answer that, even though we cannot make arguments on it. We're also asking about state action, which is an American term, but it's if something is unlawful for Parliament, can you create government policies that are non-statutory that use incentives to get corporations to break the law for you? For example, we watch what happened during COVID, right, with the Missouri v. Biden case, where you have people in Homeland Security setting up disinformation governance boards, and they're using tax dollars to incentivize social media platforms to take down content that is disagreeable with their narrative, although purposely true, right? They had to create a new term, misinformation and disinformation. Well, one of them is information that's wrong. One is just, we know it's true, it's just not convenient. And we're going to ban that too. Were there any other jurisdiction questions?
No, I was just curious if that is, and I can see that is, I know that's something that you guys have included in there, and I was just curious if there was any background information specifically relating to the health aspect. And again, like I was saying, in the grand scheme of things, like I said, you go to McDonald's and you have a 15-year-old going, can I see medical information? And technically, under the provincial laws, nobody has the authority to ask you. And I think like a perfect example of the contradiction was the fact that you didn't have to show your medical exemption for a mask, right? You didn't have to show that because it was private medical information. Yet you had to produce your pass, your jibby jab pass, right? And it was just like this. It's like a juxtapose of reality, and they're getting away with it. And that was.
They had to manufacture a form which wasn't controlled.
Yeah.
And give it a new name. Because unless you're in a hospital, if they ask for your immunization record, sorry. But if they issue you a document that's not coming through public health, that has the same information on it, and you voluntarily choose to turn that over, then
absolutely, you do volunteer to give that over, 100%. And I think most of us volunteer to give our information over, and we don't realize that we're doing that in like everyday life. We're constantly relinquishing our privacy, our data, all of these things, thinking that it's necessary, and it's not at all. So
yeah, I think most of us remember that something that rarely, if not ever, happens was all 13 provincial privacy officers came together with the federal privacy officer to release that statement saying that vaccine mandates and passports would likely be unconstitutional, and gave a whole list of controls you'd have to meet. And whatever happened to that?
Yeah.
How often you get all the provinces and the feds agreeing on something?
Yeah, and even I think it was the TTC, I forget the union for the TTC. They had a meeting and said we will never mandate the jabs because we cannot do it lawfully. Yet, a few weeks later, there it was. So
yeah, we have something similar happening here. I'm sure a lot of people got some sort of statements from authorities in their company prior to the policy coming out saying, we're not going to do that, don't worry about it.